Good afternoon and welcome to Marlborough Law Podcast. I think this is number 11. Gosh,
I have no idea.
you have
now.
no idea?
No,
That's
no.
not useful. I think it's number 11. We're now into February and I'm delighted to have another expert on our podcast. We try to get one expert a quarter, and today's expert is Richard Turner. Now, Richard is the partner at and patent attorney at Stevens Hewlett and Perkins. It's something that Marlborough Law don't do as a speciality, but we look to experts such as Richard to help us with these sort of cases. So welcome, Richard. Nice to see you.
Thank you. Good afternoon.
So Richard, firstly, can you share a little bit about your background and what drew you to specialise in IP law?
I can. So yes, I'm a UK and European patent attorney. I'm a partner at Stevens Hewlett and Perkins, and we're specialists in intellectual property law. We're a full service law firm dealing with all aspects of intellectual property law. My background is a little bit unusual. I'm a maths graduate, and so I did my law training afterwards. And I suppose the sort of big attraction is for this type of law is that it's a sort of cross section, or it's a meeting of technical, business and law. And so combines all those three things in one. And so requires quite an unusual skill set, I would say, to be a good IP lawyer.
Yeah, I know someone who's an IP lawyer actually, who's degrees in engineering, I think. So I think that happens quite often, doesn't it? It's technical expertise.
Yes, I think it's probably because most of the client's subject matter is often very technical. So, if you've got a client that's in a particular technical field, you've really got to be able to talk to them at the technical level. And it's certainly true in certain technical areas. So, for example, like if you've got a biotech client, you really need a biotech patent attorney to be able to handle their work. And in fact, about a quarter of patent attorneys actually have a PhD as well.
Wow.
Brighter than me, so not
And me.
hard. So with that in mind, I mean, who are your clients generally?
And so we have quite a wide range of clients. We deal with individuals, and then through way through startups and entrepreneurs, new businesses, through to SMEs, then all the way up to big corporate clients. We have FTSE 100 companies who are clients of ours, and we sort of basically deal with whoever comes through the door. Most of our new clients are sort of an entrepreneur, small business type stage who need us for the first time, because obviously most large companies have already existing relationships in place. We've recently taken on a new client who's a divestment out of a large French company, so they've been told to get their own IP lawyers. They can't use the existing ones. So it's those kind of relationships that we build up. But yes, we have a very, very wide variety of clients, I would say.
So do you have any international clients as well?
Yes. So lots of our clients are UK based, and then we work with them around the world depending what they want to do. But we do have foreign clients. Sometimes there's sort of an accident of history as to why they're using UK lawyers. Sometimes it's because they've got a UK presence that might be quite significant, and therefore they take local advice. So, for example, that new client that I mentioned, they're actually domiciled in Luxembourg, but their research centre is in the UK, and that's why they want UK lawyers to handle their IP.
Interesting.
Interesting. I mean, IP is not something I've done since university. I mean, how do you stay up to date with changes in IP law? And is it something which changes often, global regulations as well?
Time. And so there is quite a heavy burden on all patent attorneys and IP lawyers to keep up to date with what's going on. Fortunately, because we're quite niche, I wouldn't say easy, but it's quite good. Once you're plugged into the relevant sort of information sources, it's quite easy to keep on top of what's going on. So we have the CIPA journal. CIPA is our professional body. And then there's some quite good blogs that people use. IPCAT is a big IP blog, for example. But yes, we get a lot of sort of decisions that come through the courts relating to different aspects of IP law. At the moment, AI is obviously a big thing. So patenting of AI is a big issue. So there is a case that's going through the courts at the moment that everyone's keeping an eye on to see what that decision is going to be. It's probably going to go to the Supreme Court, I think.
Right.
Gosh.
So it's a almost everyday task to keep on top of what's going on, and things do change on a regular basis because there's a sort of constant effort to harmonise internationally as well with IP. so that get constancy of decisions around the world about IP topics.
I was going to say, so how do you advise a client who suspects that IP is being infringed overseas?
Well, infringement. So most of our work is actually acquiring rights for the client, so finding patents, trademarks, applications, etc. And then obviously once they've got them granted, then infringement can be an issue that arises. Um, the first point of call is obviously to analyze the case, see what's at stake. Is there a likelihood of infringement? If we think there is, then the first action is always to write to the alleged infringer. We find most things can be resolved through correspondence. It's relatively rare that things go further than that, but we do deal with litigation. I'm in the IPEC at the moment, which is the Intellectual Property Enterprise Court in London for a client. And so, yeah, we do litigate in the UK and around the world if necessary, depending on what's being infringed. We have some clients who have very big, well-known trademarks, who factor out a lot of infringement work. But I work on the patent side, but we still do get patent litigation as well.
So sorry to interrupt, but when you find you write to somebody, do people, I mean, what percentage of people actually realize have done it deliberately, or have they just not realized what they were doing when they set up their business or
Yes, I
something?
mean, well, there's kind of three categories of infringers. There's the kind of innocent ones who aren't aware of what you've got, and then usually they can be resolved quite quickly. Then you have the ones who are aware of your rights and have tried to steer away from them, but haven't necessarily gone far enough away. And then obviously you do get the blatant copyists who have literally just ripped you off, and they're the easiest ones to deal with because you just say, you've got to stop, otherwise we're suing you because you're right in the center of our client's IP rights. It's probably the ones who tried to steer away are probably the more difficult ones because they might have had advice on their side that they're not infringing, or
Hmm.
that we've got a weak case or whatever. So they tend to be the ones that get litigated. And it depends what's at stake as well. Always with these things, it's what is the value of the potential infringement, that will feed into the decisions that get made.
That makes a lot of
Interesting.
sense. Yeah.
Yeah, that doesn't.
I mean, how would you go about advising clients if they've come up with their own new invention?
Well, that's kind of our bread and butter work is, either an existing file or a new file saying we've got an idea, we want to patent it. Normally we recommend a search first to see what's out there already. It's amazing what has already been thought of. But if the search comes back clear, then we would file a UK patent application as the first port of call. And then the kind of patenting IP side goes along in parallel with their commercial activity. And yeah, we file around the world if they wish, depending what their markets are and what the potential value is of the invention. We have clients who file only in the UK, clients who might file in Europe and the US, and then we have clients who are filing 20 countries around the world because they've got a very valuable invention, with a lot of potential value to it.
Good. And do you advise on copyright issues in digital and software and
We do
online?
a little bit, yes. Funny enough, it doesn't come up a lot. The vast majority of our work is patent and trademark work, with a little bit of design work as well, because there has to be copying. There's only infringement if there's copying, and so it's an unusual thing to happen because most people are relatively aware of copyright.
Mm.
But we do get it occasionally. We get sort of odd cases depending, what the client's done. But the thing is, most of our clients, if you like, who are technical businesses, they don't necessarily have a huge copyright output, if you know what I mean. So if you're an engineering company,
Yeah.
what matters to you is your inventions and your trademarks. If somebody kind of copies an advert or something, okay, you might give someone a rap over the knuckles, but it's only if you've got clients who are filmmakers or, publishers, then copyright starts to become a bigger issue. And so most of our clients are what you might call technical businesses. We obviously have a few kind of retail type clients, who might trademark only, so there's a potential for copyright issues, but it's a very small proportion of our work.
No, that's interesting. I mean, how do you help businesses then protect their trade secrets, sensitive information? And what's the process?
Well, generally, if you can keep it secret, then keep it secret.
That makes a lot of sense. Yes.
Yeah.
Don't talk about it in
Yeah.
open
like
company.
like the Coca-Cola recipe, which is secret after all these years. If it's going to go out into the public domain, once you start selling your stuff, then you've got to patent it. Really, that's the only way to protect it. But then there are lots of things. sometimes, sometimes clients' products or processes can be split into two in the sense of what can we patent and what can we keep secret. And so, yeah, there is. But the thing is, it's often very hard over a long period of time to keep things secret because people move jobs, people start to reverse engineer things. Um, and so, there's very powerful tools now, even with software, to reverse engineer, you know, object code and source code and so on. So, generally, if you've got an invention, most of the time you have to file a patent application to protect it.
We're running out of time, but I just have one more question. So when you say public domain, a
Mhm.
lot of people now can, and my husband's one of them, can research the heck out of something, and can drill down and down and down and down. So what is the definition of public domain? How far down
Well, it's
is one
basically
allowed to
anything that's
drill?
been made public, even if it's sort of been put in a library and no one's ever looked at it. The fact that it's available is sufficient for something to be in the public domain. And nowadays, of course, as we all know, there are fantastic tools. And so sometimes you do get cases where somebody's found a document or something that was out that nobody knew about. I've been involved in cases where inventions have been for filing, and so then you get a debate about, what were they doing in that field when they used that invention and so on. And yeah, I was involved in a case where literally a product was used on a building site, and there's a lot of debate about what you could tell from the use and so on. So it does come up quite often in patents because you have to keep your inventions secret before you file a patent
Mm.
application. And so sometimes, there are inadvertent disclosures that can undermine an application.
Right. So once it hits the public domain, that's it, game over. You can't then patent it.
Yeah, that's correct. Yeah.
Okay.
And how long does a trademark last? Sorry, one more question.
Yeah, well, they're vastly different things. So patents last for 20 years in general.
Okay.
Designs, most places, 25 years.
Okay.
Trademarks theoretically can last forever.
Okay.
You have to pay renewal fee every year. And obviously some trademarks that are very well known have been going along for hundreds of years.
Yeah.
You obviously have to kind of protect it and make sure it doesn't, become generic. So like cornflakes is a well-known example was originally a trademark of corn of Kellogg's, but became generic. So you have to be careful. So Vaseline is a trademark that we look after, and we're also in a constant fight to bring a generic expression. Um,
So if you don't keep paying your trademark money, then that trademark goes back on the open market, so to speak, and can become generic.
Yes, yes. So if you don't pay your renewal fee, then that part of the register will become open again. Also, if you don't use the trademark, it becomes vulnerable to cancellation after 5 years.
Wow.
So that's something you can't sort of block trademarks. Um,
I bet a lot of people didn't know that.
No, I must admit I didn't know about. I thought a trademark, that was it. Once you registered, I didn't
Well, no,
realise.
so patented designs are kind of absolute rights. Once you've got it, it's yours kind of thing. But trademarks, you have to use them. So yes, if you fail to use it for 5 years, for a period of 5 years, then that will lead to the possibility of invalidity.
Oh,
That's
interesting.
fantastic. I guess I just have one final question. I mean, Marlborough Law, we tend to work with quite a few small businesses, startups, and the like. I mean, I harp on constantly about how you need lawyers involved from the start. I mean, how would you get involved in smaller businesses, not on the scale of your multinationals, who you
Yeah.
clearly seem to work with and help as well?
Yes, I mean, well, we always talk to clients. We're happy to talk to anybody. We don't charge to talk to people. And our role at that stage is always to say, right, this is what you can do. This is probably what you should do, and these are the kind of costs you're looking at. Um, there are in the Southwest a lot of grant schemes available. There's good kind of investor communities around the area and so on, angel investors and those kind of things. So sometimes we can help facilitate some of that for new clients who perhaps need investment, but ultimately everything has to be kind of paid for. And what we tend to find is that what we tend to say to clients is, look, if you've got a good idea, even if you're a startup, you've got no money at all, if you've got a good idea, you will be able to raise money. You will be able to raise money that will cover your IP costs. And in some respects, in a strange way, it's kind of a good test for clients because if they can raise money, then at least that's an indicator that they're on the right track. But yeah, we might be talking to a client and we might say, okay, so you need X, Y, and Z, and at this point you need 10K, 10,000 to spend. Okay, so they need to raise maybe 100,000. They're going to assign 10,000 for their IP budget at that point. So that's how we generally sort talk to people who've got no money, if you like. But we generally, where we're in at that stage, normally we're in slightly later where they have already raised money, and they know that they need IP.
Well, that's good to know that they can. Rich's company can help people right at the beginning, and
Yeah, it sounds like, our general advice is you need people working out how your business is going to work from the start. And I view IP as vital to that.
gosh, well, we could talk
Yeah,
forever,
yeah.
Richard, but we're running out of time. So once again, that was very interesting. We'll maybe put some of that on our website for some of our corporate clients and new businesses in the area. But thank you very much for your time today. It's very interesting. And for those of you who are looking at the podcast, details of Richard and his firm will be on our website in the next week or so. So reach out to them with all your IP problems. Thanks very much, Richard.